Thanks for staying with us on the program. Now, in the court case that has dragged for long enough, Atiku Abubakar, the former vice president and the PDP presidential candidate, predicted his plea on the grounds that presenting forged documents by any candidate, especially by one of the highest office in the land, is a grave constitutional issue that must not be encouraged. Now, the former vice president stated this in his reply on point of law to Tinubu's objection to grant leave for Atiku to present the fresh evidence before the apex court. President Tinubu had predicated his objection on grounds of jurisdiction and that the issue of qualification is a pre-election matter, amongst others, and subsequently prayed the court to deny the grant of the application. Meanwhile, in a 20-paragraph affidavit deposed to in support of the application, Atiku argued that if the apex court grants the application, there will be no need for any further argument other than the written address in support of same, showing that the second respondent is in violation of the provisions of Section 137, subsection 1 of the Constitution by presenting a certificate disclaimed by the institution from where he purportedly procured the same. Now, it's a legal issue that requires the input, of course, of legal minds, and that's why today I will be joined by my guest to help tackle this issue. Thank you so much, Barrister Mawah, legal practitioner, for joining us on the program.
Thank you, Blessing. It's a pleasure to be here again. Though you are just partial, you have commended your colleague without commending either me or Barrister Chidoke, whether we are well dressed or not, because I heard you commending your colleague.
Oh, I'm so sorry. I apologize. Oh, you look fantastic, by the way. You look dapper.
No, you too. I think I like the lining on your, your beautiful way.
Apologies for that. I should have done that earlier. Sorry about that.
No.
All right, Barrister Monday, let's go to the crux of the matter. Now, President Tinubu has maintained that Atiku is bringing up said evidence that were not included in the main petition. I think I'm going to ask, is it right to ask for it to be disregarded? Isn't that a part, or isn't there a part of the Constitution that allows for new evidence to be brought to light?
Yes. You see, we operate adversarial system of law in which we have both sides, and whoever is trying to, the law in adversarial system says that whoever alleges has to prove, especially in a criminal matter. And the proof in criminal matter is the proof beyond reasonable doubt. But of course, the one the court is faced with at this moment is a civil matter, in which the party who is alleging is allowed or is mandated to prove his case on the balance on probability. Now, what Atiku is trying to do is not really out of place. And of course, the objection also being raised by His Excellency President Tinubu is also not also out of place. And of course, you know, in law, like I normally tell people, to every issue in law, there are always two sides to it. There is no one side to every issue in law or to any issue in law. So once there is any issue in law, there will always be two sides. And there will always be, if there's two sides, any two-sided aspect to it, there will be two arguments to it. Now, first, the general rule of law is that on appeal, fresh evidence is not allowed. In other words, appeal is deemed to be a continuation of what transpired at the trial court.
Right.
In which case, the presidential election court. So whatever transpired there is what is supposed to be moved up to the appeal to look and then distill issues and point out aspects that the appellant feels the lower court err in law or in fact, and in which is asking the appellate court to give decision in his or her favor. So by law, you are not supposed to bring any fresh thing because you are not starting the case all over again on appeal. However, like we used to say in law, that to every general rule, there are exceptions. Now, there is always the allowance for a fresh evidence to be admitted or to be allowed on appeal, but it's with very stringent conditions. You are not just allowed at large to say, oh, you just wake up one morning and decide to bring in some volumes of documents or file in some fresh evidence to say, oh, when I was at the lower court, I forgot to add this. You will not be allowed. If it's on the basis that you forgot, you will not be allowed. So fresh evidence that is allowed to be adduced on appeal will be such that as at the time you were before the trial court or the lower court, there were such documents of fact that were not reasonably within your contemplation. In other words, that they were not documents available to you, reasonably available to you at that material point in time where you were before the lower court. So there are conditions that guide. One of those conditions is that the document must be such that you have taken some diligent steps to get them, but you couldn't lay your hands on them while you were before the lower court. That is one of the conditions. Then the second condition is that the document you tend to bring in on appeal, it should be such that it is so important and wealthy to sway the mind of the court on appeal. But it must not be that it is such a document that will be decisive on the case as a whole. That is the second condition. Then the third condition must be the document must be such a document that
Monday Mawah, can you hear me? I think we're having okay. All right, please go ahead. We lost you there for a bit. I think we're having issues with Monday Mawah's audio, but while we wait for him, I'm just going to give a brief background to this story while we wait for Monday. Now, the case has dragged for a long time between Atiku and Tinubu. Now, there has been allegation that the certificate that Tinubu presented when he wanted to, contest for presidency from the university he graduated from was either forged or falsified. And, the school which he allegedly graduated from claimed that they did not issue him that certificate. However, a new report by some persons who that aired on BBC says that school was a school that Tinubu graduated from. The dates did differ though, but there's that contradicting opinions as to whether or not he attended CSU and graduated from CSU or not. Now, CSU has said that they did not issue that certificate, and they said that under oath, and that is what is making Atiku want to further pursue this case. But according to Monday now, it's not so easy to just reintroduce a new evidence without exactly, having that evidence beforehand. If I understood clearly, he said that the evidence you're going to reintroduce has to be one that you have tried all your power to get and you couldn't get your hands on it, in the first instance. Monday, are you there with us? I see you nodding your head in agreement.
Yes, I am here.
I can easily pass for a legal practitioner, let me just tell you. Okay, please go ahead. We lost you there for a bit.
You need to go and pick form.
I'll think about it.
You might need to go and pick form and study law again.
I'll think about it. All right. You were saying something. Please go ahead.
Yeah, so it is not as easy as that. Now, those are the three conditions that an applicant that intends to bring a fresh evidence before an appellate court must satisfy. Now, the appellate will satisfy that. That is also not all. Don't forget, for any application before the appellate court, the grant or the refusal of same is a matter of discretion of the appellate court. In other words, when we say discretion, the court, beyond the fact that you have satisfied the condition, the court also must look at it from its own point of view. Yes, this man has satisfied the condition, but granting this application, is this just? Is it fair? Will it achieve the end of justice? So the court also must put all of this into account in order to arrive as to whether he will grant it or not. So the conditions, it's not just straightforward. Yes, Atiku has obtained some piece of evidence which, from his deposition, from his affidavit evidence, this were information he could not lay his hand on while they were before the Court of Appeal Petition Court, or the Presidential Petition Court, rather. I think that is the correct word, the Presidential Petition Court. that he could not lay hands on all of those documents after the time they were before the petition court. And that why, after the judgment, that he got hold of those pieces of evidence. So, and he's begging or praying the Supreme Court now, which is the apex court in Nigeria, to allow him to bring in this fresh evidence. So, even if he's able to succeed in crossing that hurdle of the court granting it, it's one thing to admit a piece of evidence. Another thing is also to look at the probative value that will be attached to that piece of evidence. Of course, you have rightly mentioned the provision of section 137, sub 1, paragraph J of the Constitution, which provides that anybody who presents a forged document to INEC will be disqualified. Now, before you can also come to a conclusion that a piece of document is forged, there are also procedures you must also pass through to achieve that.
I mean, Monday, apologies, but what if it's a situation where it is clear as day? I mean, a report by the BBC, like I said earlier, has indicated that I take that back. A report by some persons that was aired on the BBC, because we did get to learn that those people were not actually employees of the BBC in itself. Now, the report has indicated that the president indeed finished from the university, and it's quite conflicting because the school itself says otherwise. So if it's a very clear, obvious evidence that, well, Atiku got his hands on, but everyone can see, isn't that, grounds for exemption, or the same rules apply? Because it's looking like a very tedious process.
Blessing, nothing is ever that clear in law. It's never that simple. Now, we are talking about a document obtained from a foreign university and a deposition made in a foreign court. Now, also, before a foreign judgment can become applicable in Nigeria, there's what we call registration of judgment under our own law. There's also a procedure that also must pass through to become a judgment acceptable in our court here. Now, of course, he has laid hand on the document. You see, the court on that basis, the court cannot sit wherever it's going to sit. The Supreme Court will not sit and say, oh, I heard on the news, I heard some persons also made a provision or submission on the news that the city's CSU denies certain allegations, denies the graduation of this. The court will not rely on that, basically. Right. It must be an evidence also adduced before the court, which the court must be satisfied with before the court can reach any kind of finding. And don't forget, issue of forgery is criminal in nature. And for you to succeed in a criminal trial, you must also prove your case beyond reasonable doubt. Now, what is agitating my mind at this point is how the issue of proof is going to be done in Supreme Court at this stage. But of course, I'm not trying to be to talk as if I do not understand the fact that there's an affidavit evidence that they have decided to take to the apex court. But beyond that, there might be a need also to call oral evidence to come and show. And in the case of Obaseki and the PDP, the Supreme Court has stated a position that before you can say there is a forgery of a certificate, the issuing institution must also be called as a witness to testify to the effect that, one, this certificate you are talking about does not emanate from our institution. And the issuing institution must also present the original one to counter the forged one. So you can see why I said it's not that straightforward.
But
so
hasn't that happened already, Monday? Because we hear that the CSU... No. Okay.
That is CS. We are talking about a court that sat in the United States, in one of the states in the United States of America. We're not talking about what is applicable in Nigerian court here.
Right. Okay.
So it's a complicated issue. And of course, I don't want to delve too much into the substantive matter so that I will not preempt what the learned justice of the Supreme Court will do eventually. And like we used to say, this, I'm one of the believers, I'm one of the followers of the realist school of thought, that when the chips are down, the prophecy of what the court will do and nothing more pretentious. That is my belief of what the law is. So as it stands now, all we are all trying to say now, we are all trying to opinionate. We are all trying to say what we believe or what we perceive the law is. But until the Supreme Court decides to give a final decision on this very vast subject matter, this very interesting subject matter at the moment, nobody will be able to tell where we are going to end this matter. I think that is the little thing I can say on that for now.
Right. Right. I mean, it's little to you, but it's a lot of insight for us over here, especially we who are not very, legally literate yet, because I'm coming for the forum. But anyways, still talking about this verdict and the ruling and, the court proceedings in general. This case, especially the issues of the document, whether or not he graduated from the CSU, it's become a jaundiced issue because the documents are not exact. There is a lot of inconsistency, and this kind of speaks volume about the country in itself. So doesn't this put a dent on our name as a country, speaking of our integrity?
Well, I think at this point I want to talk as a lawyer as well.
Oh, you've been talking as what?
I'm going to talk as a lawyer, not as a journalist like you, or as a politician, which I don't think I am. But the point is this: as a lawyer, one of my training is not to speculate on any facts. And as also a lawyer, Section 36, I think sub 5, what I think of the Constitution, presume any person, everyone innocent of every allegation until it's proven beyond reasonable doubt by a court of competent jurisdiction. So as it stands now, of course, I've listened to some politicians from different parties. Some will even come on the public debate and say, oh, Tinubu is a forger. But by my training, I'm not allowed to do that.
Right.
The reason is simple. No court has convicted him of forgery yet. And until that is done, I do not possess the legal toga to begin to address His Excellency our president, as it stands today, until the court says otherwise tomorrow. Right. I have no power, I have no capacity to begin to adjourn him or describe him as a forger. So as at this point, we are seeing in the realm of speculation, allegation, and what have you. So, well, it is until the Supreme Court now decides to take a stand and take a decision on what we are having today and what we are saying is clear and it is obvious, like you said earlier. I don't want to use the word rightly said earlier. So until the Supreme Court makes a finding and come to a conclusion, I am not permitted by my training to adjourn or to come to a conclusion as to the image this is going to give to country. Because if I do that, I would be convicting the man before the court convicts or says otherwise. So I think at this point in time, even the international community, of course, we have some others that are also not legally inclined, just like we have in this part of the world. But the very inclined people in the international community, as at now, will not adjourn us as a country of forger until a decision is reached, which will eventually bring to an end these lingering issues.
All right. I mean, rightly said, and that does speak to your level of professionalism in the field of law. But now, talking about precedents, I understand that there is a thing called precedents in law, if I'm not mistaken. Now, if this issue is handled light-handedly or waived or not taken seriously, wouldn't that set a precedent? That's if all the documents have been vetted and, conclusion has been made, because now, of course, we cannot speculate. But if it's not exactly handled the way it should be handled, wouldn't it set a precedence for more issues like this in the nearest future?
Definitely, Blessing. Definitely. And we are praying and hoping that the apex court, you see, there is something I tell people about the justice of the Supreme Court. According to Justice Hugo, one of the very renowned justices of the Supreme Court of the United States, of blessed memory, he once said, and I quote, he said, the Supreme Court is supreme, not because it is infallible, but it is infallible because it is supreme. And what is the meaning of that? He said, don't forget, when a matter gets to Supreme Court, not just only in Nigeria here, but across the world, even in the United States that we are modeling our democracy or democratic system after, when a matter gets to Supreme Court, beyond the issue of law, they begin to consider issue of policy. And that is why they call the Supreme Court the court of policy, not just court of law alone, but court of policy. Now they begin to look at what will best suit the country. They begin to look at what will be the effect of what is before them on the country. Because any matter decided by them, you have no other right of appeal to any other court, except you want to appeal to high heaven, like we jokingly put it. So in deciding, in coming to any decision, the Supreme Court over the year, and which I also believe they are also going to do in this instant case, always take into account various interests, public policy, and every other thing beyond the issue of law. So they bring that into play in arriving at their decision. So I have no doubt in my mind that the learned judges of the Supreme Court, we are talking about 7 terribly learned men here that are going to sit over the matter at the Supreme Court. I have no doubt in my mind that if it escaped one, it will not escape the second one. If it escaped the second one, it will not escape the third. Before it escaped them to the 5th, 6th, I know the 7th justice of the Supreme Court would have tracked down whatever is wrong. And I'm hopeful that this judgment at the end of the day will leave the court better for what we used to be.
Right. Now, talking about the current administration, the Tinubu-led administration, we see that since the president came into power, he's been making efforts, working on reforms, trying to get the country out of poverty, trying to introduce different ways, to make living basically better for everyone in the country. Now, I guess what I'm trying to ask is, with this whole proceedings going on, isn't this kind of a major distraction for the country at the moment?
Definitely it will, because as we stand now, there's what we call this sort of debacle is hanging on the man's neck. Whether you like it or not, it does not, if he sleeps 5 hours per night normally or peacefully before now, with this matter hanging on his neck, I can tell you that man cannot sleep peacefully for 5 hours anymore. Because you
well, allegedly, since we're using legal terms.
Yes, because you see, the man told me something one day. He said there are 2 people he fears so much. After God, the next person is a judge. Because, for instance, look at what happened in the Amechi case. Somebody won election, Omeha, and then suddenly the matter got to Supreme Court. The Supreme Court said no. It was the man that won the primary for PDP. That was the man that is the governorship, is the governor of the state.
Right.
And Omeha was removed, and then Amechi brought on board. And also, don't forget the case of Rivers, what is it called? Bayelsa State, where they were preparing for swearing in 3 days, 2 days to swearing in of the governor-elect in what is it called? Bayelsa. And 2 days to, the man was already even practicing how to take salute, how to do parade and all of that.
Yeah.
And no, it was a day to the swearing in that the Supreme Court delivered judgment disqualifying his running mate. And by law, once your running mate is disqualified, you, the governorship candidate, you automatically disqualify because you cannot run the ticket all alone.
Right.
So can you imagine a man preparing for swearing in? He has invited people both from far and near. They even made close. And overnight, the Supreme Court gave a decision that pumped the scape of political affair in that state. And so, what do you want? People are also having this mindset that anything can happen when the matter is before the Supreme Court. It's not just as easy. People are making it look like, oh, the court is biased. No, I think the court has done that several times in the past. And
all right,
anything can happen again.
All right. Legal practitioner Monday Mawah, thank you so much. It's been very insightful, interesting, I must say, segment discussing this with you. Thank you so much for joining us on the news.
Thank you, blessings.
And I'm coming for my form very soon, so just a heads up.